welcome. Thank you all for joining us today. My name is Chris McKenzie, and I'm the Vice President of Communications for Americans for Responsible Innovation. Today marks an important moment. With the House passage of the Take It Down Act expected tonight, Congress is poised to take a decisive, bipartisan stand against the spread of non-consensual deepfakes and intimate imagery online. This is more than just another bill passing through Congress. It's a long overdue step to protect people, especially vulnerable communities, from exploitation in the digital age. The Take It Down Act will finally require tech companies to act swiftly when harmful, non-consensual, intimate images appear on their platforms, giving victims a path to relief and accountability. The legislation is a testament to what can happen when policymakers come together to tackle a pressing technological harm. It's a signal that Congress can find bipartisan solutions to protect the public online. At ARI, we're proud to have played a role in building broad public support for this effort, and today we're fortunate to be joined by leading voices in the legal community and in tech policy who can comment on the bill's legal grounding, its impact on speech and NCII, and enforcement of the legislation. A warm welcome to our speakers, Tim Wu, Professor of Law at Columbia University, Zephyr Teachout, Professor of Law at Fordham University, Slade Bond, Chair of Public Policy and Legislative Affairs at CUNY Gilbert and Leduca, Stefan Turkheimer, Vice President of Public Policy at RAIN, Adam Billen, Vice President of Public Policy at ENCODE. With that, I'm going to turn it over to some of our speakers for quick opening remarks, and then we'll take questions from the audience. Tim, how about we start with you?
Sure. It's a pleasure to be here, and thank you for coming. I'm very happy that this bill is going to get signed. It represents congressional response to harm that are known and well proven, and really doing extraordinary amounts of damage, as evidenced by the testimony of the many victims of this kind of harm. I think, generally speaking, that human impersonation rarely goes well, and that this is something more broadly that Congress should be acting on as representing an actual visceral harm that many people are experiencing. And I'm very happy that this ended up being a bipartisan effort. We worked, when I worked in the White House, we worked and tried to pass many similar laws, and I'm glad we're finally getting something done and hoping this is the beginning of more to come. Thank you.
Thanks so much, Tim. We'll go to Slade next.
Yeah, and I just want to echo a few of the things that Tim said. This is such an incredibly important effort. It's a pleasure for me to join you at today's press conference in support of the Take It Down Act. I wanted to focus just narrowly on some of the constitutionality issues at play with this bill. I welcome Zephyr and Tim's thoughts as well. First, this is an area where the Supreme Court has been abundantly clear for decades that the First Amendment is not a shield to the type of content that the Take It Down Act is designed to address. The First Amendment does not shield criminal activity like sharing CSAM or engaging in sextortion through deepfakes. And decades of black letter law make clear that the bill closely aligns with First Amendment principles and America's tradition of free speech. In terms of some of the concerns we've seen with the bill, I think it's important to kind of break these down because they're kind of scary on their face, but don't really withstand scrutiny when you actually drill down. So from a legislative drafting perspective, I worked on the Hill for over a decade. I think this bill is incredibly well drafted. It draws from current law extensively. It gives courts clear instructions on how to evaluate criminal liability under the act. But I've seen two main criticisms. The first, that it's constitutionally overbroad or vague, due principally to an alleged lack of definitions in Section 3. And the second is that it could be weaponized by the administration. So first, on the bill's scope, this could not be further from the truth. So the bill draws from the definition under the Violence Against Women Act's reauthorization in 2022 for intimate visual depictions. It includes exceptions for things like commercial pornography. It has other common sense exceptions like speech relating to the public interest or matters of public import. So it's really clear this is a really poor vehicle to shield speech that would be, like sex art or criticisms of public officials. It would not apply to those, and that type of use of the bill would not withstand judicial scrutiny. Lastly, on this issue of whether it could be enforced on a politicized basis, it's really important to remember that the bill does not give the Federal Trade Commission new authority. It clarifies that the Commission can use its existing Consumer Protection Authority under Section 5 of the FTC Act, which applies to unfair or deceptive practices. And this allows it to find a covered platform that fails to remove NCII online. So again, the definition of what this actually covered is extremely narrow. And on top of that, you have decades and decades of jurisprudence applicable to the FTC's use of Section 5, which is also arguably too narrow. And so it seems to me like it's a very poor tool to actually go after the types of things that some people are concerned about, and not discounting the basis of their concerns, but whether this would be the right tool to reach that type of conduct. And lastly, in terms of proving to a judge that it would cause substantial injury to consumers, that is not reasonably avoidable, and other lodestars of Section 5 enforcement of the FTC Act, I just think there'd be an incredibly high burden for any FTC to do that, particularly under this law. So on balance, again, this is addressing an incredibly important issue, as you'll hear in today's press conference, to the extent that there are any however far-fetched scenarios where either the constitutional firmness of the bill would be challenged or there are some issues with the bill, we should not let caution be the enemy of progress. There are millions of people who hang in the balance the lives of people, their financial security, their emotional well-being, and we should weigh in favor of them.
Thank you, Slade. We'll turn next to Stefan from Rain.
Thank you, Chris. I'm Stefan Turkheimer, the Vice President of Public Policy for RAIN. We're highly in favor of this bill. We really look forward to passing the House tonight and going to the President's desk. There's a couple things that I just want to point out. RAIN is best known for running the National Sexual Assault Hotline. And as part of that, people come to the hotline to complain about all variety of things, but including image-based sexual abuse, like you see here. And one of the notes about this is, like, you're going to hear people talk about how 40% of high school kids have either had this happen to them or had someone they know affected by it, or, 17% of women between 18 and 24 have had, NCII spread around them. But like whatever number you're talking about is out of date and is too low. We see on the hotline that this number is doubling every month just in the people that are calling us. And so when you think about, even when you think about the burgeoning and huge numbers that we're talking about, they're all too low when you're thinking about this. And so when this is a real harm that a lot of people are experiencing, that every single time that they get a text message or they go on the internet, they may see themselves and a non-consensual image. That is the real problem, and we're balancing against it sort of a not a mythical, but it's sort of a hypothetical problem on the other end, which is that some people's speech might be affected. And like, I recognize that that's the balance you always have, but it's very important to think about this on the front end. And so we're really grateful to be here amongst these other professional lawyers and plus Adam. And it is thank you for being here, and thank you guys all for your support of the bill.
Thank you, Stefan. We'll hear from Adam now from Encode.
Thanks, Chris, and thanks for having me here. Similar to Stefan, I want to cover a little bit of why we sort of got invested in this issue in the first place, which is that over the past few years, we've been doing some tracking of every publicly reported case of this happening in schools around the country. And what we've found and what others have seen as well is that there's a very disturbing and consistent pattern that occurs and a very rapid spread of that type of content being distributed. And from looking at that pattern and starting to work with some of the victims themselves, it became very clear to us that there were two big gaps in actually solving the issue. And the first was inconsistent or frankly non-existent federal criminal penalties. And the second was an inability for victims to take back control of their images once they had been published online. And in our mind, the Take It Down Act very carefully patches both of those holes. I think others have covered Section 3 and the criminal penalties quite well. I want to touch briefly on encryption, which I think has been a major criticism raised against the bill. And here I would point to a couple key provisions. The first is the definition of covered platforms itself, which Representative Trahan helpfully pointed to at a recent markup. And that is that it explicitly covers services that provide a quote unquote forum for specifically user-generated content. And the way that definition is written, it would not cover things like private messages, encrypted DMs, anything like that. So it explicitly carves that out already. The second, which also does this, is that Section 3 only covers content that's been published, which is very different than distributed, which I think is the language people are traditionally used to with revenge porn law. But published means something very different than distributed in this content. In this context, this is the public posting of materials, which also explicitly means that things like private DMs are carved out of the bill. And the final thing I would point to is that the DMCA, which the Take It Down Act is modeled off of, has existed for 27 years, and platforms have not been required to break encryption or remove encrypted content to stay compliant with that legislation. And it's also held up under all sorts of constitutional challenges for the entire time that it's existed. And so in our mind, encryption simply just is not a question under this bill. And we have explicitly opposed other legislation that would explicitly break encryption. So I thought it was important to touch on that piece here. Thanks.
Thank you so much. And before we turn it over to our final speaker, Zephyr Teachout, I want to remind folks who are attending, please feel free to put your questions into the Q&A box on this Zoom webinar, and we'll take those and have our panelists respond. Zephyr?
Thank you so much for doing this panel. This legislation is extremely important. The terrorization of so many children is truly unacceptable, and it is actually, as horrifying as it is, it's exciting to see the possibility of the first major federal legislation in this arena in a long time. I want to just briefly touch on two things. One is the long-standing tradition in the Supreme Court of allowing for laws that protect the physical and emotional well-being of children. This is a principle the Supreme Court has upheld many times over the decades. And the second that I just want to point out is that for many years there was a sort of, I think, fairly sloppy assumption that big tech regulation would be struck down as unconstitutional. And what we've seen in the last year alone in the United States Supreme Court is that the justices, Amy Coney Barrett, Jackson, and others, are very focused on the particular facts and understanding the reality and the shape of the legislation, and the nature of the drafting really matters. So as a result, we saw in the net choice case last year, the TikTok case in January, and the pending Paxton case, the oral argument in that case, is a Supreme Court that was highly open to regulation of tech platforms in cases where the legislation is narrowly drafted. In net choice, the Supreme Court remanded, much to many people's surprise, remanded to the lower court for a much more close examination of the Florida and Texas laws. In TikTok, the Supreme Court refused to strike down as facially unconstitutional the divestiture ruling in the divestiture rule in TikTok. And in Paxton, there's a discussion of an age verification law. We have yet to see that opinion, but from the oral argument, we could see the justices very aware and I think curious and in-depth and focused on the practical realities of trying to protect against harm in today's social media environment. So I'm very confident this is an extremely well-drafted law, and it will be upheld.
Thank you so much. With that, we're going to take it to some of our audience questions. First, we have Kirsten D'Souza here. For years, social media companies lobbied heavily against the passage of any tech legislation in Congress that would require companies to change their services. What's different about the Take It Down Act, or what has changed about the environment that won their support? Tim, you've been engaged in tech policy battles for some years now. Maybe you want to chime in.
Yes. I think that frankly, I think that the tech companies have been in sort of two minds about this. They have often sort of publicly said they're okay with certain kinds of things and quietly tried to slow it down. I mean, I think at some point the balance of harms just becomes too absurd, and we have such a visceral problem with deep fake porn, particularly of minors, that being on the other side of this issue has just become totally untenable. And it might be premature to say that the tech industry is maturing, but I do think that when there's such obvious harm and the public support for these kind of laws is so strong. When you think about it, I mean, like who would be on the other side of this law? I think the position in opposition has just become untenable.
Thank you. We have another question from an anonymous asker. So is this definitely being signed tonight? Just to be clear on, the procedural side, this bill has already passed the U.S. Senate unanimously. It's now headed to a House vote tonight under suspension of the rules. That will mean that 2/3 support will be required for the bill to pass. We do expect it to secure the support necessary to pass. And then after that, it will head to the president's desk for signature. From Matthew, we have a question on encryption. Given that some encrypted platforms already implement client-side content detection for certain illegal material, do you anticipate courts to likely interpret the Take It Down Act to require only these established technical measures, or could it be construed to demand more stringent monitoring? Adam, maybe you want to weigh in here?
Sure. I think to Tim's point, this is part of why this bill has relatively sailed compared to other tech legislation. This isn't touching something like Section 230. It's not carving out encrypted content. So as a baseline, I would say that most encrypted content you're thinking about, if not all, is simply not going to be covered here. I think in terms of technical measures more broadly, including things like content-based filtering, it's going to depend wildly platform to platform, and it's just going to be based on whether they're actually able to remove the content that is reported and if they can do it consistently. And so I don't know if courts are going to be sophisticated to the point that 5 years from now, we're going to have some very specific content filtering system that platforms have to have reasonable care or something. But I think we are going to see things just based on whether they're actually consistently removing the content that's been reported. And to your point, a lot of existing tech platforms already have systems in place to remove content that's reported, for example, things like child sexual abuse material quite consistently. I think part of the beauty of this bill is that it expands those existing systems to content specifically and only for victims that are reporting that content, where it's not necessarily clear on first glance for a platform when, say, an intimate image of someone is posted, whether that content is consensual. This provides like a direct avenue to clarify that for platforms, and that's why they've been okay with it.
Great. We have another anonymous asker here. Slade, can you elaborate on your point about it not being overbroad or vague? You spoke a little quickly and would love a more detailed explanation on that point. Would love to know how this bill aligns with 1A.
Yeah, so sorry for rushing. I was cautioned we only had 2 minutes, and I was covering a couple additional points. Welcome, Zephyr and Tim's views here as well. So the first threshold question is this actually going to go through heightened scrutiny under the First Amendment? The thing that Zephyr said is really important in this area, that the Supreme Court has been really, really, really clear for decades that legislation to protect the safety of children, particularly around things like CSAM, is not going to be invalidated on First Amendment grounds. But even if you got to that heightened standard, and this is like a really interesting, academic debate, there's no expressive value associated with the content that Congress is trying to regulate, right? So we're talking about sex-based imagery that we know is not commercial pornography because the bill doesn't apply to that. We know it's not related to the public interest. It's not like sex art. It's not going to be something related to a person's views on government and areas that the court has traditionally been very protective of. It's narrowly tailored in possibly the most targeted way imaginable. And I could imagine areas where maybe it's too tight. And then the second major thing to think about is, is there a compelling interest? Is it actually tailored to serve that compelling interest? And courts have had no difficulty upholding this for a long time. So this is not the first time that the First Amendment has grappled with these issues. Federal courts have looked at things like morphed pornography, where you take the head of a child and take the body of a nude person. And they've said that has no expressive value under the First Amendment either. So I think as an initial matter, the vast majority of the speech this applies to simply is not subject to the type of First Amendment scrutiny that critics of the bill have said it is. And then second, even if you got there, the weighing, and the First Amendment's not a balancing act, but the weighing of these issues is clearly in favor of the legislation. You can't imagine a scenario, at least I'm not creative enough to, where you have a compelling interest that's on the other side in terms of speech that's not subject to the bill's exceptions. And to me, that's just really far-flung and unlikely. And to the extent that you even get there, I think there's no doubt that the balances of the interest are really in favor of the survivors here, the people that are being victimized today, and not the far-flung potential speech of someone who might be affected down the road. But finally, one point that Tim made is it's taken years to get here. It does take a long time to pass legislation, but the idea that Congress is powerless once it passes a law to amend it to address facts on the ground, or that parts of it, if held unconstitutional, wouldn't allow other parts to proceed, is just simply not true. Right? Congress is not powerless, and I shouldn't imagine that the theory that it's unable to fix laws it passes would caution against passing any new laws. That to me is unacceptable.
Can I chime in for a moment here as well? I agree with everything Slade said. I want to focus also on this question of First Amendment analysis and the big picture of what kind of scrutiny is triggered. The bill uses the phrase, which I think is an important phrase, digital forgery. And, with this, it's trying to target a narrow category of speech that is greatly reduced in its value. The Supreme Court has said in some contexts it will protect lying, but it's not illegal to criminalize fraud, forgery, impersonation. There's all kinds of laws in the books that, for example, prevent yourself from dressing as a police officer, even though that may, express something about yourself or something like that, or lying to someone about a weight loss medication or a cancer cure. There's all kinds of speech that is criminalized being essentially fraudulent or deceptive, and that is a mainstay of law enforcement, both by the states and the federal government, and that is what this is targeting. This law targets digital forgery, so I think this entire thing, it at some level works into an entirely different kind of mode of analysis when you're talking about government's traditional role in protecting people, and here it's protecting victims of the forgeries from something that is long been a target of law enforcement activity in other contexts. So it's adapting impersonations or forgery laws into a different context. And I think that's very important for the First Amendment analysis. I wanted to also say something. One of the anonymous questioners said, is this bill likely to pass tonight? I mean, I would like to see a member of Congress who wants to be on the record voting against a bill like this, voting against a law that is trying to make it easier to have to deal with pornographic deepfakes online. I mean, I would love to see how that works in their election campaigns to be labeled on that side of the issue. So I just wanted to put that out there too.
Stefan, looks like you have a comment here.
Yeah, I just wanted to piggyback on what Tim said. I think one of the interesting things about this whole thing is that this is one of those bills that can only get killed in the dark. It's only one that you can sort of not get to committee or not get to the floor or whatever. If someone has to vote for it, they're going to vote for it. And the reason why is because all of this stuff, whenever you describe it to someone, they realize how patently offensive it is. And obviously I'm using that term by intent, because it's like the reality is that when someone actually knows what you're talking about here, not like sort of on the edges of people trying to make up a hypothetical to challenge its constitutionality, but the reality of what deep fake sexual image-based sexual abuse, or even just regular NCIA is, the privacy that is the inherent privacy violation that's there on top of the obscenity or whatever else analysis you want to do, really gets to the point of how much this all favors, not just in favor of the constitutionality, but just it is strongly favors sort of passage that this is something that Congress needs to regulate. This is something that survivors need protection on.
Yeah, and let's add to that. I mean, let's get real here. It's probably 95% of the public, if you told them about this, they probably assume it's already illegal. And surely 99% of Americans, I mean, it's only inside DC that this is seen as controversial, even remotely. And I want to say, I hope this is the beginning. I mean, there needs to be more protection. I don't want to get other issues in this call, but, this is an area where there's all kinds of visceral harm. And this is one example. And if any of these bills in this area received a vote, they are so popular and so obvious to most of the population that more needs to be done to protect children and vulnerable people. That is kind of shocking how inactive Congress has been. But this is a good start, and I'm glad we're going to see this pass tonight.
All right, with that, we're going to take it to our next question. Do you expect this bill to end up in court like other online content laws we've seen? Do decisions in the net choice cases mean anything for take it down? Zephyr, maybe you want to speak on this one?
Yes, it'll surely be challenged. I think it has a much steeper a hurdle than any of the cases that I mentioned. And I mentioned those cases, net choice, TikTok, and the age verification Paxton case, not to say that this is similar, but they all indicate that the Supreme Court recognizes that just invoking the internet doesn't mean that something is going to not only be called unconstitutional, but necessarily be subject to strict scrutiny. So in the net choice case, which was remand on the grounds of it being inappropriate for a facial challenge, the Texas and Florida laws, Justice Kagan focused on the intent. And in as much as she was sort of chastising the states, was clearly concerned that there was a non-viewpoint neutral intent. None of that exists here. I think more importantly for the net choice case, again, I mentioned these before, but you see Justice Coney Barrett and Jackson really rising as important leaders in thinking about online regulation. In the Paxton case, something that, again, it's not exactly analogous, but you saw the justices in the questioning being really bewildered by the idea that if you could require an ID to go into a bar, you couldn't require an ID to go online. And what I think you're really seeing is that there was a reliance by the challengers, and I'm sure there will be here for a long time, on a kind of mystical view of the internet. And instead of that mystical view, the justices are asking real questions about what is the harm? What is the nature of the alleged expression? Is there a real expression that is being suppressed here? And so while I do think those cases, I want to be very, very clear about this. I think those cases make it far easier to uphold this bill. But I don't think we are in the same range as that bill, because in this case, there is not only as in net choice and TikTok, where Barrett recognizes there's some algorithmic content that isn't deserving of any speech regulation. The core conduct here is not deserving of First Amendment protection. And that's really important. And why, although I think you will see challenges, I think this is a much easier case than the ones that I mentioned.
Yeah, I agree with everything Zephyr says. I predict on behalf of myself that it will be challenged and the plaintiffs will lose. And I say that I think the relative comparison is not net choice or other things, but ACLU versus Reno and the child pornography cases. If you compare this bill to the original Communications Decency Act in the 90s, it's completely different. That bill, and which is what the plaintiffs will want to say it's like, but that bill was the entire internet, and anything that was indecent should be taken down. There's so much of a gap or a gulf between that kind of bill and this, which is targeted at a specific form of fraudulent digital forgery that has demonstrated harms to a lot of people and is narrowly tailored to that objective. It's night and day, and I think that's the kind of analysis. This is much more like the child pornography related laws, and I'll leave it there.
Our next question is for Stefan. What number does RAIN recommend journalists use when reporting on the prevalence of NCII and non-consensual deepfakes? This is something you brought up during your open remarks.
Yeah, that's a really good question. We are a survivors organization. We tend to focus on the effect of survivors rather than sort of pure numbers on like what has been discovered on the internet. So we tend to use the numbers from the Center for Democracy and Technology and from Thorn. And I'd be happy to send over our numbers list after, if anyone would like, either through Chris or on our own, whatever is easiest.
We have another question here. Could you elaborate on how all of the definitions are narrowly tailored? You mentioned something about VAWA.
Yep. So this is really important because one of the criticisms of the bill is that it doesn't define the term intimate imagery. And the definition for that is actually coming from the cause of action that Congress enacted in late 22 as part of the omnibus, to the point that was already made. A lot of times when you have a vote, these are really compelling issues that Congress cannot look past, and these types of changes pass on overwhelming bases, as that law did. So that law has been construed by dozens, I think it was like 53 at my last check, federal courts. None that I read actually looked at the definition of scant. And so there's not been a serious discussion of this definition as one that would trigger the type of scrutiny that Tim's describing in the broader, far-reaching Communications Decency Act context. And so there have been dozens and dozens and dozens of causes of action under that law. And again, it's been upheld routinely. And this is where the narrowly tailored part of it comes in. If you actually look at this law, 15 U.S.C. 6851, it actually covers all the things that the critics of the bill want to be covered in the exceptions. And that goes back to does not apply to commercial pornography, does not apply to matters of public interest or import. And those are areas that could apply to lots of things online that, range from criticisms of the government, which obviously you would want to be protected under the First Amendment, to sex art, to actual commercial pornography, or other things that are clearly beyond the boundaries of NCII or deepfake pornography. In terms of the other elements of the bill, it's important to remember that this creates a criminal law, and the criminal law has the highest burden of proof there is beyond a reasonable doubt. It is really hard to prove that. And it also includes a number of limiting factors that narrow the scope of the bill, such that you have to show criminal intent, you have to understand the expectation of the privacy of the person whose image was captured, and so on. And so there are a number of limitations that really, as you go through each of them, and it's an and, not an or, you have to satisfy all of these elements. The world of the bill is actually quite small in terms of its enforcement scope. So I think this is a rifle shot. I think it gets at the exact issue it's designed to address. And again, I really can't imagine a set of commercial speech or otherwise that the First Amendment would protect that this bill would get at.
Adam, looks like you have a comment.
Yeah, I just want to throw one other thing, and not on the criminal penalties, but on the FTC side of this, which is that I think one of the consistent things that's been thrown out, like Slade mentioned, is this question of commercial porn, specifically the idea being that somehow the definitions are inconsistent between the two sections. Section 3 carries the same definition of intimate visual depiction that Section 2 calls on. And even if it didn't, and the commercial porn exclusion was not included, if commercial porn was produced non-consensually, one, I'm not sure it would even technically be considered commercial porn under existing law. And two, if it was non-consensual, it would still be covered under this bill because it is non-consensual. If it is consensually created and published commercial porn, it is not covered under the bill for both Section 2 and 3. If it was non-consensually created and uploaded, then it is and should be covered.
Yeah, and Adam, I think you may even give the critics too much credit here. So the criticism is that Section 3 of the bill does not have a definition. If you scroll down, Section 4, which is conveniently called definitions, applies to the entire bill. So it's a facially absurd argument. And frankly, it's borderline bad faith to say that Section 3 doesn't have definitions. But even if, going back to everything Adam said, courts, again, have construed this term of art, which only exists in the context of that 22 law I described. So the idea they wouldn't import all of that case law applicable to that law here, to me, is also incredibly unlikely.
All right, we're going to take a couple more quick questions here, and then we'll move to our closing remarks. Next one is, will this bill be retroactive, or will it only apply to content posted after the bill is signed? Anyone want to chime in here?
Are they asking about the criminal section or the civil section? Because
I think this is regarding the criminal section.
Yeah, the criminal section will not, we can't post past. I would like to, obviously be retroactive here, but no, absolutely not. On the criminal, no one who posted this 10 years ago is going to get in trouble now criminally.
Thank you. Last question. Can you address concerns that Take It Down might be abused by Trump's FTC to target platforms he's feuding with?
I can take a stab. Also, welcome Tim's perspective as an FTC alum. So again, the words in the bill matter. And so you could have like a really interesting debate without actually looking at the bill on like this kind of shadowy rogue enforcer concern. But I want to start from the premise that, when I worked in Congress, tech-funded opposition to bills always focuses on this. There's always some type of villain, either on the left or on the right, that's going to use some new authority in a way that is categorically offensive or harmful. And it never happens. Right. So this has been used to stymie antitrust legislation, consumer safety legislation, privacy legislation, and the harms are almost always theoretical or unconnected to the bill. Here, the thing the FTC gets is something it already has. So it has the ability to police unfair or deceptive acts or practices. That standard has been in the law for decades. Courts have narrowed it quite a lot. I think Zephyr, Tim, and I probably think too much. But the point is the idea that they would use this authority to enforce the authority it already has to go after a very small subset of speech online versus any speech it doesn't like ever under the same authority, to me, again, doesn't withstand scrutiny. So if they wanted to do it, they could do it already. I'm not going to say whether or not this FTC is capable of doing that. I think that's kind of beside the point. We can imagine like a worst case scenario where, if they wanted to do it, would this be the right tool to do it? And I just think that it's not. I think that it's politically unhelpful as well. Like the idea that you're going to abuse an authority that was crafted after substantial input from survivors who came all across the country to testify in support of it, that to me is like politically hazardous in the extreme.
I'll add only that the current president doesn't seem that he has much particular need for laws if he wants to go after his enemies. He just goes after them directly. And the idea that like the missing link for is this obscure law enforced by the FTC that criminalizes deepfake porn is suddenly going to become the missing weapon in an arsenal. I mean, we have a problem with a lawless president. I think there's no question about that. But the word lawless is kind of important in that. I say this for myself as an observer. And, the idea that somehow this is the key turning point in what is already a relatively lawless attack on institutions and other lawless behavior is frankly a ridiculous concept.
Great. We'll actually leave it there and offer folks a minute for closing remarks. Tim, if you want to kick us off again.
Yeah, thanks. I'm pleased to. This bill is long overdue. This bill targets one of many obvious and visceral harms that have affected vulnerable groups, including minors, over the last decade. And, the fact that Congress does something is heartening. I think it's the beginning and not the ending. I think that the reality is clear. The internet is an extraordinary and important invention, as is social media and are the other technologies, but it comes with real world harms that have hurt people. And it is the duty of government to protect citizens from harm. And that's what Congress is doing. It's doing its job. And I would be surprised if this isn't unanimous. And I see it as a step in the right direction and a sign of more to come.
Zephyr? Or we...
Sorry. But there's no more fundamental obligation than to protect children in our society from profound, lifelong abuses and harm. And it's especially important to stand up to some of the most powerful companies that are profiting and want to have an immunity from legal regimes that no other industry has. So I think this is a really important moment. Will improve millions of people's lives. And as Tim says, it's just the beginning.
Thank you. We'll go to Slade.
Yeah, just briefly, as we've discussed extensively today, this is an incredibly important bill. It addresses a real world harm. It's been well documented, perhaps even under-documented, as Stefan has noted. And there's an incredible urgency to act now. We are seeing new technologies, it feels like every day, that are creating the possibility of endless torture for young people, women, minorities, vulnerable communities online. This is not, like, the stakes are very large. In terms of the countervailing harms, this idea that we're going to regulate speech that's protected by the First Amendment, I hope that idea has been thoroughly debunked today. The bill does not apply to speech that is traditionally some that enjoys First Amendment protection. And even if it did, it has very, very, very little, if no, expressive value. And to the point of, the other criticisms of the bill, I would just encourage reporters to actually open the bill. It's very easy to read. It's well designed. The definitions are easy to follow along. And I think it's such an incredibly important effort.
Stefan?
Yeah, thank you so much, Chris, for convening this group today. I think it's super important to be able to answer these questions for everyone. Standing here from Rain, this is a bill that will make a real difference in the lives of survivors. We talk to survivors every day, obviously on the hotline, but even in our legislative work, where people talk about like what it was like to find out that someone had made images of them and were spreading them around to their friends and family, and the damage that that caused and the feelings that they had about removing themselves, not just from the internet, but just from sort of daily life, and that every single chime from their phone they thought would be another person seeing their images online. That we can end that Congress is going to take the step to end that tonight is huge for survivors. And it really proves not just that they can do something here, right? But that they can do something to protect survivors and to protect people on the internet that hasn't been done. That sort of after the creation of 230, we've all had this sort of deference to this group, to this special industry to protect them from all the harms that they create. And this is one where we're actually taking a step back. So I'm really glad to see it happen, and I'm really grateful for all of you for your thoughts.
Thank you so much. Adam?
Yeah, I would just say that I think it's very rare that Congress gets the chance to act on an issue while it's still in the early stages of getting very bad. And there's a beautiful opportunity right now for, I think, maybe the first time on particularly revenge porn to do something right in the very early stages before it gets a lot worse. I think Congress and the states were very slow to act on revenge porn. And part of that is that there was 5-10 years of litigation trying to figure out what the right scope of First Amendment protections is to put in these bills. And we have figured out what they are, and all of those protections are in this legislation. So this is the chance for Congress to learn from 10 years of legal cases and challenges and do the right thing here.
Thank you so much. And I'll just close it up by saying thank you so much to all of our attendees, everyone who's logged into Zoom today, everyone who's watching on Twitter and YouTube. And thank you to our speakers. I really appreciate all of you taking the time today. We're really excited to watch tonight's vote and hopefully see the Take It Down Act pass and head to the president's desk. This is a huge moment, not just for what it means for survivors, which, as Stefan so eloquently put, this is going to change lives and protect a new generation of victims from NCII. But this is also a big moment for passing tech policy legislation. It is proof of concept that Congress can do it, that lawmakers from across the aisle can come together to address online harms. So thank you everyone today. And with that, we'll close it out.